In the immediate aftermath of the 9/11 terrorist attacks, America was having an existential identity crisis. The nation had to choose what was more important, security or liberty, and we were asking a lot of big questions, like what is more harmful to America? Terrorism threats to homeland security or the erosion of civil liberties? One way to think about this dilemma is through the dual criminal justice models of crime control and due process. On one end of the spectrum is the crime control model, which emphasizes the need to protect the public from the next potential attack, even if it means sacrificing rights and liberties. On the other end is the due process model, which emphasizes the priority of protecting constitutional rights and liberties, even if it means occasionally letting the guilty criminal or terrorist go free. The question is, where is the right balancing point on this continuum? Just after the 9/11 attacks, Americans were in shock, and it was generally felt that the attacks were sufficient reason to tip the balance, albeit temporarily, toward crime control and away from due process. We were willing to give up some personal freedom to keep us safe from the next attack. Over time, as we realized the 9/11 attacks were not going to be a regular occurrence as a new way of life, the U.S. gradually swung back towards reprioritizing concerns of due process and the protection of civil liberties. Immediately after 9/11, though, legislators and government officials wanted to take immediate action. Law enforcement, particularly the FBI, felt time was of the essence when it came to their ability to follow leads and tips that may prevent another potential terrorist plot. They argued for increased discretionary powers to monitor people living in the U.S. to investigate terrorism. This led to the uniting and strengthening America by providing appropriate tools required to intercept and obstruct terrorism, or USA Patriot Act. Completely coincidental abbreviation. Just kidding, of course. It was introduced on October 23, 2001, passed the House on the 24th, passed the Senate on the 25th, and was signed by President George W. Bush on the 26th. This is lightning fast compared to other major pieces of legislation. Most legislators later admitted they had not read any of the bill. This speaks to the sense of urgency of the moment, but it also speaks to one of the criticisms of the Patriot Act, that there was too little debate and scrutiny of the provisions of such a transformative piece of legislation until long after it was passed. The Patriot Act gave law enforcement numerous additional authorities, the general purpose of which were to prevent terrorism by identifying plots and assist in ongoing investigations by removing roadblocks and providing additional resources to law enforcement. However, these expanded authorities have come with tremendous concerns over threats to civil liberties and individual rights, particularly protection from unreasonable searches, seizures, and detentions, along with other changes such as an increased emphasis on providing military equipment and military-style training to law enforcement. The criticism is that efforts to fight the war on terror have removed checks, as opposed to roadblocks, on what the police can and cannot do, and threaten the very rights and freedoms they are aiming to protect. This is important context to keep in mind when considering the extent to which even greater authority should be given to the government to root out ongoing domestic terrorism threats. So, let's go through some of these expanded authorities and concerns raised about them. Let's begin with surveillance. With the Patriot Act, lawmakers wanted to increase investigators' ability to intercept communication between those plotting against the U.S. One way of accomplishing this was to allow roving wiretaps of terrorism suspects. This gave law enforcement the ability to move the target of the wiretap from a single phone at a single location to a person, allowing them to monitor the communications of persons of interest as they moved across jurisdictions. This is a highly valuable tool for law enforcement in the age of cell phones and the internet. It allows law enforcement to be able to adapt to the changing nature of threats, as the way wiretapping warrants were previously issued had not kept up with changing technologies and the now mobile and global nature of communication. The criticism of this provision is that judges are unable to effectively monitor the extent to which the order is being used, and it ends up amounting to essentially a blank warrant where the court issues the order and law enforcement fills in whatever places they want to search. Another controversial surveillance tactic is a once-secret program run by the National Security Agency, or NSA, to collect phone records in bulk, basically data from every call made in the U.S. This is the program that was revealed in 2013 through leaks of classified documents by federal contractor employee Edward Snowden. These warrantless record-collecting capabilities have been curtailed in recent years. The USA Freedom Act of 2015 removed the authority to collect bulk telephone and internet metadata, and the U.S. Supreme Court in 2018 ruled warrantless searches of cell phone records containing information on physical location was unconstitutional. And in a related side issue, the court also ruled against warrantless searches of the digital contents of cell phone devices following an arrest in 2014. The NSA continues to collect hundreds of millions of records each year, although the data collection is more targeted, focused on specific individuals, and it is a far cry from the hundreds of billions of records captured annually before 2015. There are wildly different views as to whether the government should have this authority and whether it is an effective tool for terrorism prevention. Views also differ widely as to what Snowden did when he revealed the program's existence. Some view him as a whistleblower, others as a traitor. The Patriot Act also controversially allowed investigators wider access to Americans' personal records. It permitted the FBI to send national security letters to banks, libraries, telephone and internet companies, and many other businesses requesting customers' private information. Essentially, all the FBI needs to do to obtain the records is make the broad assertion that the request is related to an authorized, ongoing terrorism or foreign intelligence investigation. When it comes to credit card transactions, investigators have access to records held by third parties with less judicial oversight and without reasonable suspicion and probable cause standards. These third parties do not have to warn the targets of the investigation that their information was requested or provided. It is also possible for investigators to access library records, which critics argued is a violation of First Amendment rights. Again, an authorized investigation was the only requirement needed for the request. There was also originally a gag order placed on librarians prohibiting them from sharing any information about these requests. Naturally, this really upset librarians, and the law has since been changed, removing the gag order, allowing librarians to consult with attorneys prior to releasing information, and limiting the number of FBI employees who can make these requests. The Patriot Act also allowed for delayed notice or sneak and peek warrants by law enforcement. Typically, when law enforcement goes to someone's house, unless there are exigent or emergency circumstances, they need to obtain a search warrant and present it to the target. With these delayed notice warrants, there is no need to immediately notify targets of warrants, which means they could be executed without the target's knowledge, such as at a residence while no one is home. This raises concerns over violations of Fourth Amendment protections against unreasonable searches and seizures. A related criticism is that this provision is applicable to any federal criminal investigation, not just suspected terrorists. As a result, there has been a steady and dramatic expansion of their use, and now very few sneak and peek searches, less than 1% per year, have anything to do with terrorism investigations, while nearly 3/4 of them are instead issued for drug investigations. Other controversial provisions of the Patriot Act relate to civil protections for immigrants. Critics have accused the act of depriving immigrants, in some cases legal permanent residents, of their basic human rights. It holds that immigrants can be removed from the U.S. if they have committed a crime involving a weapon, or for having connections or providing resources to foreign groups involved in terrorist activities, whether intentional or not. The basis for this determination can be particularly vague. Essentially, within 7 days, detainees have to be charged with a crime or placed in the removal process to be deported. If they have not been removed in 90 days, such as when their country of origin does not want to take them back, an additional 6 months of detainment can be ordered on a continuous basis, potentially leading to indefinite detention based only on reasonable suspicion if the Attorney General believes they pose a threat to national security. As mentioned 2 weeks ago, these changes affected the Department of Homeland Security's response to illegal immigration far outside the context of terrorism. We'll conclude by asking the question, what should the objectives of counterterrorism efforts ultimately be to achieve a balance between security and liberty? There are a few issues to consider. Naturally, one of the primary objectives is the disruption and prevention of terrorist conspirators from operationalizing their plans. At the same time, strategies should be selected that minimize collateral damage, including human casualties and physical destruction. It is important to implement strategies that promote a cooperative counter-terrorist environment by building partnerships that work toward reducing terrorism while also improving the lives of citizens. Many governmental and non-governmental organizations actively monitor trends in extremism and promote programs based on community inclusiveness and countering extremist ideology and hateful messaging. This includes efforts to deter activists from crossing the line from political activism to extremism and then potentially to crime or violence. It is important to focus not just on addressing potential terrorist threats in the short term, but to implement long-term solutions that promote social reform and political inclusion. When more people are brought into accepted political processes and given a voice to air any legitimate grievances they have, they are less likely to be tempted toward embracing extremism. This does not mean giving a platform for extremist ideas, but rather is an attempt to address some of the underlying conditions that lead to them being embraced by greater numbers of people in the first place. Shows of force are often necessary to address immediate threats, but they can backfire, and it is important to look beyond the immediate threat to what comes next. Trying to counter long-standing cultural, political, and religious tensions through coercion or force alone may quell it temporarily, but end up spreading it out further to others who are persuaded to adopt more extreme views due to what are perceived to be overreaching and harsh tactics. So, essentially, we have to be on guard against sacrificing long-term stability and security for highly visible, short-term, quote-unquote, wins. And finally, protecting constitutional rights and treating people with fairness, dignity, and respect is crucial. Otherwise, we risk sacrificing who we are as a people and the ideals we stand for. Many terrorists view the erosion of citizens' civil liberties as a direct result of their actions as a victory. It's one of their underlying goals, to make us overreact out of fear, to give up what we cherish most. Some communities feel their constitutional rights have been routinely violated by being targeted with surveillance, harassed by law enforcement and others, and just generally being treated with suspicion of being involved in terrorism, regardless of anything they have or have not done. This is especially true for Arab and Muslim communities, particularly in the aftermath of 9/11. Just as Black and Hispanic communities are more likely to be suspected of engaging in crime and often feel targeted and fearful as a result, Arab and Muslim communities are more likely to be targeted as terrorism suspects. As noted last week, one of the major barriers to gathering intelligence is the distrust many communities have of the police. The public is critical to counterterrorism, but if they don't trust law enforcement, they're not going to work with them or share important information. As a result of feeling targeted and profiled, these communities often avoid contact with the police, even when they need help, out of fear that doing so will do them more harm than good. This has negative long-term consequences, and substantially increases the chances that crucial information will fall through the cracks. Ultimately, this does not make any of us safer. And while there aren't any easy answers here, there certainly are balances worthy of working toward achieving.